Hi, I'm Melanie.
I'm Alex.
We're from Awad and Baker Law, and we're here today just to have some chats and conversations. I want to start off with the fact that Alex is now starting her
Mm.
10-year anniversary as an attorney. So you've been admitted for 10 years now. Walk us through what that's like.
I can't believe it's been 10 years. I got admitted in the second department. It's down in Brooklyn. My dad took me to get to sign the book and be officially become an attorney. And I just can't believe it's been 10 years. I feel like I've lived like a number of lives. Most of it has been personal injury litigation. I did do a few stints on the defense side and in some real estate law, but I started in personal injury and I've come back to personal injury after gaining a lot of experience in other areas. I remember my first appearance in court. When I reflect on it, I feel like I've become a much more confident attorney, and I would hope so after 10 years. But I remember my first appearance going to court. I had 4 appearances in Nassau County, and when you have that many, as you know, you have to go to each part and sign in and run up and down on the floors. And every appearance was on a different floor. I had no breaks. And it was a lot as a first year attorney, especially doing it by yourself, but you've learned so much from it. And back then, it was really helpful that you could sit in the courtroom and you listen to everyone on the calendar call. So you can hear what are the bad arguments that attorneys are making, what are the good ones, what are the things you don't want to say to a judge, and what are some better things to say that other, colleagues, fallen colleagues have said that have gotten them yelled at.
What advice would you give for a first-year attorney?
My advice is even if you don't like going to court, go to court. Going to court and gaining that experience is so vital because you get to see one, how the court rules and functions and what they're concerned about. And you also get to hear other cases going on, and you can pick up a lot from other people's arguments and from what the judge likes to hear versus what they don't like to hear. And you just gain confidence that way. Like, again, I remember my first appearance, I had 4 cases. I had so many papers with me trying to figure out where I was, and I was totally flustered. And one of them was a wrongful death case, which should have been a clue. But at that point, I was so overstimulated and nervous that I was in chambers with about 6 other defense counsel. And the judge was like, plaintiff's counsel, have you gotten your client's IME done, which is an independent medical examination where someone would go to a doctor's office to get examined. And I'm flipping through my papers, sweating, and a defense attorney, a nice defense attorney leaned over to me and she said, "Hey, your client's dead. There's no IME." I said, "Your Honor, my client's deceased. There's no IME." But now reflecting on it, yeah, I can see why I was so nervous. But it's those moments where you gain the experience, you gain the confidence, and you gain the knowledge to just keep doing it better next time. And even if it's not that much better, it's always a little bit better each time. And then you gain the confidence to be even not only talk before a judge, but talk before a judge with like 60 attorneys who are all in the same county as you and know your name and know your firm. And you gain that experience and you get comfortable with it.
Shouldn't every attorney before they go to court really know the case that they're going before, or a lot of attorneys just show up and try to wing it?
Well, a lot of attorneys do show up and try to wing it, but don't be that attorney. A lot of my fallen colleagues that I've seen get yelled at in court are the ones who appear and say, "Judge, I'm sorry, I'm just covering this file for now. I'm just appearing today." They don't want to hear that. The court rules specifically say they want someone who has knowledge about the file. I don't want just a warm body here. What does that do for me? We're trying to move the case along. We're trying to resolve it. How can I do that if you're showing up and telling me you're only someone I can talk to for 20 minutes on this appearance, and yeah, there's not much else for you to say. You got to show up and know the file. And plus, it looks really good when you know the file a lot better than your adversary knows it. It's a lot more convincing and persuasive to a judge and a jury or a law clerk who's handling the matter to be like, Miss Awad knows this case front and back and her adversary doesn't. I'm going to give her what she wants, or I'm going to tell him he's got to give me a little bit more. You got to know your case front and back. So before you go, for example, in a personal injury case, I look at the summons and complaint. I try to figure out who represents who am I going to look for in the courthouse? Because sometimes we can have conversations and resolve things ahead of time in person. I'm going to look at what's called the bill of particulars, where we plead what our injuries are. Because, like, the least you should know is your client's name and what their major injuries are, and if there's been surgery. There are some judges who it's like a pop quiz. How old's your client? Is there a loss of consortium claim? What labor law codes are you under? What are you pleading for negligence? What are your major injuries? Has there been surgery? Are there liens on the case? Like, these are all things that matter. It's kind of like when you show up to look at a house where the realtor and you ask how many bedrooms there are and they don't know, or you ask, what school district is this in and they don't know. That's not impressive. And it's not professional. It doesn't get you anywhere. You got to know your case.
And does it apply differently being a plaintiff's attorney versus a defense attorney when you're in court? Because plaintiff's attorney, we have to prove our case. We have the burden of proving our case. So do the judges direct those questions more so to you than they do to defense counsel?
Yes, and it's important for both sides to be prepared, but especially the plaintiff side, because as you said, we have the burden. We filed the suit. It's our burden to prove the case, and then when we prove our case, then can the defense come in and defend it and say, no, this, and that instead. It's our burden, and plus, every judge has standard and goals as to how fast they want a case to be resolved. The judge is getting pressured from their supervisors to say, this case has a 2021 index number. It's now 2026. We're going to year 5. We got to get this case resolved. Who does that fall on? It falls on plaintiff. Even if it's defense who's dragging the case, plaintiff has a number of tools they can use to ask for court intervention and say, Judge, I got to move this along. I got to meet my burden, move this along. Because even if it is the defense side's fault that something's dragging, it's also the plaintiff's counsel's fault because they need to say, hey, they're out of line. We need help getting back in line. The plaintiffs do have a heavier burden in that respect. And that's why it's so important to be prepared.
Of course. And like you just said, when you prepare a case when you're going to trial, or no, you're going to court, you're preparing to go to court and you look at the summons and complaint, that's what we allege. And then you also look at the bill of particulars, which is also what we allege, the negligence, the injuries. So let's take a step back to when a client first contacts us and we get the initial information from them about how the accident happened, what the injuries are. That's when we have to obtain the medical records, right? To see what's documented so that we can allege those injuries in our bill of particulars. So what do you think is so important? Like, what is the client's job? What's the client's role when they get into an accident?
The client's job about, coming in and figuring out what injuries we're pleading is, one, to know all the medical providers who you've been treating with since the accident. And then I need you to be honest to me about prior injuries to the same body parts. Because if you had the same injury or an injury to the same body part, I don't want you to hide that because the defense is going to find out and it's just going to ruin your credibility. And being upfront, there are ways to deal with that. You don't need a clean first time injury in order to plead it and to claim it in a case. Well, there's something called like exacerbated injuries, aggravated injuries. Hey, I fell down some stairs like 5 years ago now and I hurt my shoulder, but if I got in a car accident today and it got worse, that's an aggravated injury. So then they would look at my images of my shoulder from 5 years ago and they compare it today, and I can have a doctor look at it and tell me what the differences are. And then I can also testify as a plaintiff and say, yeah, I dislocated my shoulder 5 years ago, and it would, not to get too personal, it would pop out every once in a while, but that hasn't happened in 3 years and it hasn't stopped me from doing other activities. But now that I got hit by a car and I'm in this car accident, it's returned, and it's either returned the same or it's even worse now. And my medical images can prove that.
Yeah.
So it's very important to be upfront and honest about that. And I also, one, is important to be credible, but two, like, it's the digital age. Like, there are records of everything. Even if it's, a trip and fall case and not a motor vehicle case, the insurance has the ability to look up any insurance claim you've ever made with your car. And it could generate like 20, maybe one of them is a personal injury claim and 19 are property damage. But like, we got to know if you ever had a personal injury claim in that respect as well. Even if there was no lawsuit, that information comes up if you file a personal injury claim. And, we can deal with that in other ways, but you got to be honest about it because that's something we can deal with up front, and you want to do it right the first time. You don't want to say, oh no, there's been no prior injury to the same body part. And then we get medical records that show it. And then we say, oh, sorry, let me amend my pleadings. We can amend the pleadings to a certain extent, but you've already tainted your credibility. So it's really important to be honest up front. Yeah. And along that as well, just from like recent personal experience, look at your medical records after your doctor generates them. I'm guilty of not looking at my medical records. Sometimes
Same.
I don't want to see like what ranges I'm in and things like that, but you got to look at your medical records because sometimes doctors get it wrong.
Yes.
And for example, like I've had a client who they had a trip and fall over a pretty gnarly crack in a sidewalk. And in the medical record, well, they came in and said to me, I tripped and fell over this. Here's the picture. It looks like it's been there for a while. So I'm comfortable with notice and things like that. It's right in front of the building. And they told me they just tripped and fell. So I said, okay. But then we got the medical records, and there's an entry that says tripped and fell because they saw a mouse scurry across. And I was just like, okay, well, we're going to have to deal with this now because if I were a defense attorney, that's the first thing I'm going to say. I'm going to say, you didn't trip and fall because of the crack in the sidewalk. You tripped and fell because you saw a mouse. And when I asked the client about it, they said, no, that's not right. What I said was, I tripped and fell over the crack and I was on high alert already because I was looking around. I saw a mouse there a week prior and I was just on high alert and I still fell. I said, okay, so your testimony is that you didn't see a mouse that day. You were already on high alert because you previously saw a mouse, but that's not what your medical record says. And your medical record, we recently had this analogy in one of our cases is, kind of like your modern day wiretaps. We're not wiretapping, someone's listening in. What's the actual truth of what's going on? That's all in your medical records. So it's really important to look at your records. And if they're incorrect or you feel like the doctor documented something incorrectly, raise that with them and have them correct
Absolutely.
it.
Yeah, there are such things as addendums. Doctors can make addendums to their records, to their reports. Maybe they looked at an image and they didn't mention something that you think is important, and they go back and they can make an addendum or a correction to the medical record. I think Alex is right. It's important to look at your own medical records and make sure that what you're saying is documented. Oftentimes, a lot of these medical records, they're boilerplate, they're in the system already, they're generated. So it pops up the same information that you might have had from 2 years prior that now has changed. You need to make sure in your medical records that that information has changed and updated.
So it's no secret that working in the legal field can be very stressful. How do you decompress, Melanie?
Well, I have 2 young children as well at home. So the only way I can decompress is I have a trainer at the gym twice a week. Having a trainer holds me accountable to make sure that I appear, because if I knew she wasn't there, I would probably just say, not today, I'll skip it and just go to the gym tomorrow. And I probably would never go. But that's something that I use to decompress, and I enjoy working out. I like to go for long walks with my kids on the weekends, go for hikes. What do you like to do, Alex?
Well, I don't like going to the gym, but I go outside, I go hiking, I go on walks with my dogs. I have 2 dogs that keep me very accountable because if I don't take them on at least 2 walks a day, um, I'm gonna be overstimulated by 5 p.m. So I do also really like hiking. And Melanie and I have been a few hikes together across the country.
We
We've hiked
sure
a lot.
have,
We've
yeah.
hiked in the Hudson Valley. We've hiked in Colorado in the Rockies and
That was
Denver.
fun. That was fun.
We've hiked.
Virginia.
Oh yeah,
That was one of my
hikes together.
our first hike. Alex took me on this hike that
It was Harper's Ferry in Virginia.
it was yeah, I thought I was in shape because at that time I was also going to the gym, and I was pre-children, and Alex was like miles ahead of me on this hike. It was strenuous, but I really enjoyed it.
It's a great hike. It's Harper's Ferry. It's where the center of the Appalachian Trail is, and there's a headquarters there for you to visit. But yeah, that was our first hike.
Yeah.
That was a lot of fun.
That was when you were still planning on doing the Appalachian Trail.
Yeah.
Yeah.
And then my foot surgery happened.
Yeah.
And the rest is history. But yeah, we've done a lot of hiking in the Hudson Valley.
Yeah, Bear Mountain.
We did in Pennsylvania,
Mhm.
up in the Adirondacks as well. I like hiking a lot. I love it. And a lot of times I get a lot of clarity in hiking. As much as I don't want to be thinking about work when I'm hiking, sometimes you have these epiphanies where you're like, oh, I'm going to do this, this, and that on a case, or I'm going to, pivot and do this, this, and that. And that happens to me quite often. Even just walking my dogs around the block, I have the notes app on my phone and I find myself dictating into it, saying, here's what I want to say in the motion, or here's a discovery demand that I want to make on this case. Because it's really important to step outside the office and, be away from all that noise and all that traffic of people coming into your office constantly asking questions, which is fine, but you got to get away from that noise. And I find that I get that clarity when I'm hiking. And hiking is not really that much different than personal injury litigation. Like, you start at the trailhead, you think this is manageable. I see the end. I know exactly how I'm going to get there. I know what the trail is, and I got high energy. Like, let's go. And then, as Melanie and I have personally experienced, in the Catskills, that one,
Yeah.
Overlook Mountain was fun.
That was fun.
Yeah, to find fun. He made it though.
Yeah.
Oftentimes you have to adapt. You think you know what the trail is going to be. You think, oh, I just have to hit this mark and this mark and this mark, and then I'm going to be at the view at the very top. A lot of times you got to adapt. A lot of times there's like unexpected terrain. There's, steep, unexpected steep areas. There's motion practice, or you're blinded by some kind of, something that gets served on you that you didn't know about your case from the defense, things like that. And just like a good hiker, you have to be prepared for any kind of condition. You got to adapt and you got to pivot. At the end, the destination is the same, but you got to be able to have the skills to adapt and change to get there. And I find that hiking is a lot like personal injury litigation in that respect. You got to adapt to the conditions. And, if you're hard headed and you're like, this was plan A and I'm sticking to plan A, you might not get to the destination.
So true. It's like, how many times have we hiked, or when we were hiking in the Catskills and there was a little bit of a snow on this mountain and I could not climb up this snow. For the life of me, I could not climb up the snow. And I was about to give up. And, sometimes you do feel that way in personal injury litigation. Sometimes there's challenges that you feel like you can't overcome, but at the end of the day, like you said, you have to just pivot and come up with ways to get around it.
With that analogy as well as, sometimes, strategy is better than speed. It's, we want to get to the top of that mountain that we did. That was for my 30th birthday, right?
Yeah.
And now that you bring it up, I do have a vision in my mind as you on all fours try to walk this vertical wall and slipping. And we said, okay, let's not become a rescue story where we need to get rescued. Let's pivot. And we backtracked a little bit and found a different route that had less incline. It was more manageable.
Yeah.
And I find that those kind of skills, are the same set of skills we bring to our cases.
I agree.
You just got to adapt to the right terrain and have the right tools to do so. There have been times where we hike and we say, you know what, there are fresh bear prints here, which we did in Canada in the middle of nowhere. And we said, you know what, let's turn around and find a different trail.
This is not a good idea.
Yeah, this is not a good idea. We thought this was going to be great. We thought we knew what to expect. The unexpected happened. We realized we're a little in over our heads. Let's pivot and change strategy. And we did. And then we ended the day with a nice dinner.
Yeah.
That wasn't so nice.
Yeah. I also feel like having something that you can decompress with and de-stress with helps you not to feel burnt out. And that helps you at the end of the day representing your clients. It helps you be a better worker or a better friend, a better partner. I really feel like if you take the time to think about something that decompresses you, gets you rid of that stress, it helps you navigate your case better. It makes you go to work that Monday even more eager and motivated. But if you're continually working, not taking any time for yourself, you're going to feel burnt out. You're not going to have the energy. You're going to feel that exhaustion, the fatigue. So it's important for mental health to think of ways to navigate that.
Yeah, and talking about my 10-year anniversary, that's a lesson I learned like halfway into my career. I became very burnt out at one point in my career, and I decided to resign from my position and go elsewhere. And I moved locations as well just to get a whole new, being in a whole new environment. And I wish that I had known then it's okay not to work 7 days a week. It's much more important for you to get away on a Saturday or Sunday than to get something else off of your to-do list. It's very important in any field, and especially the legal field that we have experience in, from even legal assistants, paralegals to attorneys. It's very important that you get that time to yourself.
Yeah, and you can still have a career.
Yeah, you can. You can still have
You can do it all.
You can. Yeah. You just gotta, take care of yourself.
Exactly. Speaking of taking care of yourself and mental health, what do you feel about the recent decision that came from Meta?
Oh, so there was a big verdict this week. It's one of those, Wild West frontier litigations against Facebook, Meta, about social media addiction. I'm an adult and I find myself addicted at some points to social media. I love scrolling on TikTok.
That's
And
another way to decompress sometimes, right?
yeah, it is. And there are healthier ways to do it. And I'm trying to be better.
Yeah.
um, but yeah, so it had to do with a young woman out in California who claimed that she had severe mental health injuries from a result of addiction to social media growing up, especially when you're a female in your teen years. You're very vulnerable to outside influences. And the litigation mirrored, or not mirrored, it was very similar to, for example, like addiction to tobacco. That's something we all know now. There was a ton of litigation against big tobacco decades ago. And social media is not that different. It's deliberately designed to keep the person engaged, and especially if it's a child or a teenager, um, it becomes problematic because now you're influencing a child and their development and it has a huge impact on their mental health. All the studies especially focus on young women who are very prone to developing mental health issues because of social media. So the plaintiffs counsel put on trial out in California, and said, here's all the evidence that they deliberately designed this. It's no different than when the big tobacco had scientists look to see what level of nicotine is enough to keep them hooked and come back and buy more, but not, scare them away or drive them away. What's the amount of chemicals I have to put in this, potato chip to get your brain to say, I want more of that. Let me eat more and buy more. It's the same kind of science. It's, hey, how do I get these viewers to engage with the content? Because the more engagement we get, the more advertisers pay us. How do we get them hooked and addicted? And we all know it's the dings on your phone, it's the limited time span of like 10-second videos. So we all have short, attention spans now. It's, getting that dopamine hit. Instead of sucking nicotine out of a cigarette, you're now scrolling and you're liking, or you're looking and people are liking all the stuff you post. Um, but yeah, that's going to be a new frontier. We grew up when Facebook just started.
Yeah.
I remember when I went to college, I had to wait to get a Facebook because they were just developing it. Or I was,
A certain
um,
age, I think you had to
yeah, I was
be.
a certain age.
Yeah.
I was dating someone older at the time, and he had one, and I couldn't have one because I was still in high school, and it was like that was all new. And like, look at it now. It's
It's like anybody can have Facebook. Anybody
anyone
can
can
have,
have it,
yeah.
anyone can be targeted, and you don't even have to actually like something for social media to know that you like the content. Even if a video of dogs come up, I don't like it, but I watch it and knows I watched it, and now it's going to feed me more videos of people who also liked watching that, similar content. So that's what it is. It's driving an addiction. It's, the same thing as people who wake up in the morning and say, I keep a pack of cigarettes on the table so I can get my first drag right when I wake up before I even put my feet to the ground. It's the same thing. I pick up my phone from the nightstand, I scroll, I get that first dopamine hit and it keeps me
Mhm.
going. And a lot of that is negative. It's just negative on your emotions, on your
Yeah.
mental health. Um,
And I think sometimes it's like unrealistic expectations of what a woman's body should look like, because of plastic surgery and AI and filters. So I think a lot of young women scroll onto their social media, look at other women and think, this is what I should look like. And I don't look like this. And that can cause some mental health issues and depression,
yeah, and I don't know a lot of specifics about the case that just came out with Meta, but I would imagine it's something like that as well,
of course.
especially with a young female. Um, and then there's also, a lot of bullying. I mean, it's the same thing.
It sure is.
It's
Yeah.
all the social media giants just perpetuate it. They know exactly what they're doing and they do it anyways. And it's because it puts a nice profit in their pocket. So that's why um, the California jury, they issued what's called a compensatory award, which is to make you whole. And now they're going to decide punitive damages, which is, you know what, we didn't like not only do we not like what you did, and we found that you're at fault for it, now we want to punish you. And depending on the state that you're in, you can get punitive damages. And it looks like you can do that in California. You can do that under certain circumstances in New York as well. where it is just, telling the company, we see right through you. We don't like it. Don't ever do it again. And we're going to punish you for it. So, Mel, what big case have you been working on?
I've been working on a few. I actually nursing home case. It was like a sad case story situation where a client of ours called because actually he was calling on behalf of his mother who had knee replacement surgery, and she was in rehabilitation, starting to heal and doing great on the path to recovery. And unfortunately, one of the aides that was helping her in the bathroom didn't use this device correctly. It was called a Steady Susan to help her assist her going up and down from the toilet. The device wasn't used properly. The brake was not applied, which caused her to fall on the knee that she just had replaced, causing her to have a further surgery. It took away her chance to have a full recuperation. It made her have to have an additional surgery, further rehabilitation. So we handle a variety of cases that are just not strictly medical malpractice. We do handle nursing home litigation that also can include like pressure ulcers and sores. What kind of cases have you worked on with nursing home litigation?
I've also worked on a lot of pressure sore cases. I've worked on some cases where there's negligent supervision. Oftentimes, the problem is, as a lot of people know, especially if you have loved ones in nursing homes or rehab centers, is they're short staffed.
Hmm.
And that's where a lot of the problems come up is that, oftentimes, for the example you gave with the equipment that wasn't used properly, the record will say, this patient needs to be a two-on-one lift. And sometimes there aren't two people to do the lift. And then one person will try and someone will fall out of bed and break their arm. And now, that becomes a negligence case. I've worked on cases about even just with negligent supervision is adequate security, where you have patients who have dementia who are supposed to be in a locked floor. They somehow get out, even though they're supposed to have they're called wander guards. So or bed alarms, if they get out of the bed, the alarm's supposed to go off. If they pass a certain point with the wander guard, it should go off. They shouldn't be able to come out of a secure door, and they do, and they leave the premises. And those are kind of the stories you hear in the news where they find a body in the morning, or they find someone wandering the street in the morning who escaped at night. Those are nursing home negligence cases.
And that's somebody's loved one.
Yeah, who they paid someone who's making a profit to take care of the loved one to make sure they're safe and secure, and they're not. So those are other types of nursing home negligence cases that we have. I've also been working a lot of labor law cases. I have a host of clients who either got hurt because they were not provided with the adequate equipment to do their job and they got hurt, or the job site was not kept up to code. There are a bunch of codes out there that apply to every construction site. You got to clean debris. I mean, that's pretty common sense. You can't have a littered site. You're creating a lot of tripping and slipping hazards. And lo and behold, you leave some debris on the floor and someone trips and falls or slips and falls and they get hurt. And,
Mhm.
that's why these industrial codes exist, because we know what causes injury. And if we follow the rules, then we can prevent some of these injuries, and we don't follow them. Wow, gee, someone got hurt. Like we didn't see that was foreseeable. Okay. And then we have, a number of falling object cases as well, which is also under the labor law.
So what are some recent strategies you're using during mediation to try to settle a case? Because let's face it, not every case goes to trial, right? Most of them typically settle.
Correct. Yeah, and they settle for a number of reasons. One is the main thing, and you'll hear it if you go to mediation. If you have a good mediator, which we always do, we love the mediators that we agree and consent to on cases.
We know who
Um,
to use and who not to
yes, and
use.
they will always tell if our client's there with us, which we like to have the client with us. For the most part, they'll tell the client, like, look, mediation is mediation. This is about both sides managing their risk. Do you want to risk having a bunch of strangers in a jury box deciding your case who could just look at you and say, I don't like what she's wearing, or she seems snotty, I'm not going to give her any money? I mean, that's risk. And the same risk is for the defense is, are they going to like the defense attorney? Are they going to say, I hate corporate giants. I don't care what happened. I'm going to, side with the plaintiff here. That's all about managing risk. With mediation, oftentimes too, as a client, we tell them, just because we have mediation doesn't mean it's going to resolve, but it's a good step towards resolution because it forces all the parties to bring at least some of their cards to the table. Um, I come from a background and a perspective that I don't want to hide all my cards. If I think this case can be resolved at mediation and my client can be happy and we're happy with it, I think it's a great opportunity to resolve it without going to a jury. And by the way, trial is expensive. So not only are you taking the risk of putting your hands in the fate of, of strangers, you're also risking losing a lot more money.
And that money, yeah, it could be also money that, like, let's say you do go to trial and it costs like another $50,000 that ultimately comes out of the client's recovery. So that's what we have to weigh the risk of going to trial or mediation. I also think mediation is helpful because at least you're getting an idea of where are they at as far as like money. If they're way below the standards of what we think our client's case is valued, we're going to trial. But if we're at the middle point, at least we have an idea where this is going. And the good thing about mediation, if I'm correct, Alex, mediation is not a binding decision. So a mediator is there trying to get a resolution. But at the end of the day, you have the right to say, I don't accept this, the client. And that's why we have our clients present to make, because our clients are ultimately making that determination.
Yeah, that's correct. Our job is to give advice and say, we advise you to take this, or we advise you to let's buy some more time here and let's see if we can get more money on the table. So what we don't want to do is leave money on the table and take 90 cents on the dollar, right?
No.
But again, it's about managing risk. The thing with mediation about learning from the other side is I find it helpful. Even if it doesn't resolve, it is incredibly helpful because now I see what how the defense is actually viewing the case. I can also see when the defense attorneys are misreporting the case to their carriers. And oftentimes they ask us to have our clients present and we say, yeah, my client will be present, but I want your adjuster present because I want them to see what we're going to put together. And what we've been putting together is a PowerPoint presentation, one, to keep the mediator engaged because they're doing up to 4 mediations a day. Like how many words on pieces of paper can you read? Like it's a snooze fest. So we've changed. We do still do paper submissions, but I've personally been putting together PowerPoints to keep it engaging and interesting. And it's also easier for the adjuster to follow. And that way I know that the claims adjuster is seeing how I'm going to present this to a jury. And then I can see where the defense, where the holes in their defense are. And then I can pivot from there. If they say, I'm going to have an expert say this, this, and that, well, I'm going to make sure my expert already has that covered if they don't have it covered already.
Exactly.
It helps me. I'm allowed to supplement my disclosures. I can do that as well. Or if they want to bring up a prior injury. Yeah, you want to talk about how my client got hit in 2001 and you think that, that's relevant to his injuries from 2020 forward. No, it's not, because guess what? I can pull up all his union hours that show he's worked 1,000+ hours a year since then. You want to tell me that 2001 injury is just, what we're seeing now in 2020? No, it's not. And no jury's going to believe that. Here's my empirical data that annihilates your defense.
Yeah.
So you can give me money now, or I can have a jury give me more. So
Yeah.
you tell me.
Yeah.
So I find mediation, even, clients can be bummed out that it doesn't get resolved. It's not something to be upset about. It's very revealing for both sides. And I think when it doesn't resolve, it does put us in a more powerful position because we've learned a lot more information. And if they bring up defenses that, we really, thought about but didn't think were priorities, now we take those and we can bring them to our mock juries and say, here are the things that we think people in a jury's not going to like by our case. What do you think about it? And how can I change this? How can I frame this to benefit me? And then we work a lot behind the scenes, and if we had to get ready for trial, we will.
Mhm.
And now we're better prepared for it.
I agree.